Knock, knock. Linda, do you have a few minutes to answer some questions?
Sure, come on in.
All right. So another question that we've received from one of our members is that they want to know, where do I have to post my CCPA notice on my website? And do I have to?
Well, let's start with the latter of the question.
Okay.
If you're a covered business, then yes, you have to post a CCPA notice on your website. A CCPA notice is actually a privacy policy specifically for California consumers. So you would either post it into your privacy policy and set it out distinctly, or it could be a secondary privacy policy on your website. Meaning it could say, California privacy policy. Most people put it right into their main privacy policy. What you must post on your website is a do not sell my information link. And that's what it must say, do not sell my information. What that link should link to is not your privacy policy, but the portion of your privacy policy or your unique California privacy policy of where the people can opt out. Whether it's by email or phone call or an embedded form, that's what that link must go to.
And where does that link need to be placed on their website?
It has to be placed in the footer with all your other legal notices. It just has to be a separate call-out button. So you would have that at the bottom. So where you have terms and conditions, privacy policy, the third link should be do not sell my info. Now remember, even though you put that link there, it still only applies to California residents.
Oh, so if someone from another state clicked it, you wouldn't have to apply with it, or what would you do with that?
No, that can be disregarded. So on that link, you would want it to state that this is specific for California consumers, or California consumers. Well, that's pretty broad, Linda.
Yeah.
How about California residents? And that's people who actually live in California. Now, by the way, they can make that link if they're a California resident and they're sitting in New York. They would be able to click on that and you still have to honor it. So you can't determine it by like the IP address. That's transient. You have to determine it by, usually it's done by submitting a zip code or an address. So on your form or in your email, you'd want to get that information. Why are they claiming California residency? And you get that when you ask them to give information so you can confirm that the person who's making the request is in fact the person whose data you have.
Now, when you say, you're asking them on your form, what kinds of information should you be asking for or not asking for when you're trying to identify whether you're a California resident or not?
Well, you only ask for the information that you currently have. So this isn't a data collection method.
We should not be using it that way.
You should not be using it as a data collection method. Even though there's a lot of people from other states that submit on that, again, they're submitting to stop your usage of their data. So it's not a data collection. You only ask for what you have. So if all I have is an email address and an IP, now I'm going to get a little bit more data because now I want to know, are you a California resident? On that, I might ask, for your email address and your city and zip code. I want to make sure you're in California so that while I'm spending all this time finding your data, deleting your data, and making sure that you don't come back on any of my databases, you want to make sure that they're from California. That would be the only time. If you are, for example, if you have sold a product to these people and now they want you to stop using it, you're going to have a lot more data in your systems besides name, IP, and email. So you might have first, last name, address, bank account, credit card, city, state, zip. Depending on the product, you also know what they were interested in at the time that they purchased the product. And you may have already done, behavioral targeting on it, which is a big time violation of the CPRA, which amends the CCPA. You don't necessarily need to ask for all that information. And you certainly don't want them typing in and returning to you a full bank account or a credit card. So you would cut that off. So if that's one of the things, let's say it was a payday loan, or they don't call them payday loans anymore, they call them short-term lending. You're going to have all that information, you have a social security number. So you're not going to ask them, oh, please give me back the main social security number, or your entire bank account, or your entire credit card, and the expiration date. You don't want to keep that information exchanged. So what you want to ask them for is what's the last 4 digits, what's the last 3 digits. Similarly, if someone is asked, what information do you have on me, and you have their first, last name, address, social security number, bank account number, credit card number, maybe you have a credit report on them because you were obtaining all that information to submit a lead to a lender. Even mortgage lender, well, until this year when mortgage rates went skyrocketing, people were getting all that information and then giving multiple companies the opportunity to try to contact the consumer to give them the best rate. So they will have all that information. Now, when they ask what information do you have on me, you're not going to spit all that information back to them, especially depending upon how you're getting it to them, either through a form or on an email, because at that point, the data is now vulnerable.
Right.
The worst thing you can do ever in California is suffer a data breach. Yeah. Because now you have the Attorney General coming after you, you have consumers coming after you. Beginning in July, you'll have the agency coming after you, and it creates a private right of action. And that's going to become a really big issue because one of the things that CCPA gives is attorney's fees. So that makes it attractive to class action. So if you have enough California data that's been exposed, you may be looking at class action litigation. And that's sheer speculation on my part. Anyway, that's my concern with this whole thing. So what you do when you respond to them, like, what data do you have on me? I may give you the last 4 digits of your bank account. I may give you the last 4 digits of your social security.
Now let me ask you this. So if they are asking for that and do you have to say, oh, I have this bank account number, or do I just say I have your bank account information?
I have bank account information.
Does it have to be very specific or just generalized is my question actually?
No, you can generalize it. Yeah. Bank account ending in 1234.
Okay.
Social security ending in 0021. That type of thing. Just enough so they can recognize their own information.
Oh, gotcha.
They can fill in their own social security.
You hope so.
I hope so. Maybe. Maybe not.
So you brought up a very good question. In this original question, you mentioned that the do not sell my information link. Is that where the consumer would check box like, hey, don't do this with my info, don't do that with my info, or what do you have on me? Please correct it. Would that all be the same form?
Well, if you did an embedded form, you would give them their options.
Okay.
Don't sell my information. Well, yeah, don't sell my information. Tell me what information you have on me. Tell me who you've given that information to or sold that information to. Same thing. Give and sell.
Is it the same?
Share and sale. It's all treated, well, it's not the same, but it's all treated the same under the CCPA.
Delete my information.
Delete my information. Employers. It extends out to consumers, but I can't imagine a consumer contacting, someone who's trading in data going, oh, by the way, can I correct this? Let me give you the correct email address that I'm using now. It just doesn't happen. It will happen in business to business and will happen in employment situations. And beginning this year, you should have that option available. I will say, 99% of what my clients have seen have just been delete my information, not tell me anything.
Or not corrected, or...
No. We have had corrections come in from employees. Employee comes in and works for you for 3 years. All of a sudden they're like, whoa, my ex-wife is my contact. No, don't want to have that happen. So it's good for an employer to give the information they have to their employees and say, hey, you better double check this and correct it if necessary. Same thing with a business to business. I mean, how many times, Chrissy, have we seen a company come in and go, well, I think we signed a contract, like when we first started working for them. And when was that?
Like 20 years ago.
Yeah, like 2016. Okay, well, yeah, we better take a look at that contract and bring it up to date.
Yeah.
Now, the parties may still be working just fine together. But also you see in this contract, it's like, oh yeah, and we moved 3 states by then. We moved from New York, now we're in California. Or we moved from California, now we're in Texas. That kind of corrections you want to be able to make. So going back, you have your privacy policy. Your privacy policy lists out what data you take, what you do with that data, how that data is secured, what rights the consumer has, if any, in the data that you have, and then a special section for California privacy rights. That section, by the way, can also put out what the consumer's rights are there. Right to delete, right to know what you have and who you sold it to, right to correct, right to restrict. Maybe I want you to have my data, but I don't want you sharing it or giving it to anyone. And that's possible. You take a membership site, for example, your site, ClickBank.
Yeah.
We don't sell, but we might share, but we don't sell any of the data. Who do we share it with? Well, we share it with people who are maintaining, our records, our online records, maintaining and assisting us in giving access to various things. All of that, even though we're paying those people, we're still selling it, which is now going to convolute CCPA even more. I'm giving it to a service provider. I don't sell it. I'm giving it to a service provider to use. That's called a share under CCPA. But in my contract, I've restricted that company and say, by the way, all this data, it's mine and it's theirs and you don't use it, except in order to run this website. Now, I'm not responsible for the service provider's CCPA and they're not responsible for mine. And that's, sort of the benefit of having a service provider contract or an addendum to a service provider contract. You want to make sure that you have those contracts in place. And same thing with, for example, if you have a service provider, but you also have somebody you're leasing your data or licensing your server to, like a cloud server.
Oh, right.
They have access to all that data, and they have access to it because in part they're maintaining the server that holds it. So you want to make sure that they keep their firewalls up, that they keep, that they've done their testing to ensure that there's no outside breaches to the extent they can, or outside intrusion. Make sense?
Yes, definitely. Thank you so much.
Mm-hmm.
I wanted to say thank you all for listening for our 10-minute talk today. And if you have any questions, please email them to info@theclaw.com and we will record a 10-minute talk for you. And don't worry, we will leave your name and your company out of the questions. Thank you.